May it,
Go ahead, I'm listening.
may it please Honorable Court. My name is Oluwapelumi Afere, and appearing with me is Gbemisola Tolorunke. We appear for the defendants.
Spell the second name. Oluwapelumi.
Yes, my lord.
I got the first counsel, the name of the first counsel. Can I get the name of the second counsel?
Gbemisola Tolorunleke, rather. Tolorunleke. Tolorunleke.
Tolorunleke.
Yes, my lord.
Okay. Gbemi Tolorunleke. Okay. Okay, so this is the judgment between Mr. Michael Oshioke and Mega Plus Global Access Limited. The claimant, by way of general form of complaint, is seeking for the following reliefs. One, an order of this honorable court that the defendant paid to the claimant the sum of 895,314 naira 88 kobo, being unpaid arrears of salaries from August 2015 to June 2021. An order that the defendant remit the sum of 1,333,311 naira 50 kobo, being arrears of unremitted cumulative pension accruing to the claimant from August 2015 to July 2021 to the claimant's RSA account with Stanbic IBTC pensions. An order that the defendant refund the sum of 15,000 naira, being the amount expended by the claimant to treat an injury that happened to him in the defendant's premises. General damages in the sum of 3 million naira only for the pain and financial hardship underwent by the claimant for the upholding of his salary and pension. And cost of the action assessed at 1 million naira. At trial, the claimant, in proving his case, testified as CW1 and adopted his witness statement on dated 14 November 2022. CW1 tendered the following exhibit, which were admitted and marked as Exhibit C1 to Exhibit C10. Provisional letter of employment was marked as Exhibit C1. The confirmation of employment letter was marked as Exhibit C2. The employment agreement dated 3rd May 2015 marked as Exhibit C3, letter of promotion marked as Exhibit C4, letter of Appendix 1 marked as Exhibit C5, letter of resignation marked as Exhibit C6, letter of appeal, copy of letter of appeal marked as Exhibit C7, Stanbic IBTC pension statement marked as Exhibit C8, and 3 medical treatment bill partly dated marked as Exhibit C9, and bank statement of Access Bank Stanbic IBTC dated and marked as Exhibit C10. The claimant's case is that he was employed by a letter of provisional offer of employment. His employment agreement put his yearly gross salary at 2,313,388 naira 76 kobo. His employment was confirmed by letter dated the 16th of February 2016. He was promoted to the position of General Admin Manager in September 2016. His salary was infrequent. He experienced underpayment and non-payment of salaries in some months. He used 3 banks for the receipt of salaries, which are Access Bank, Stanbic IBTC Bank, and Sterling Bank. In a tabular form, he presented the summary of salary payments received from the defendant, the balances, the dates of payment, and the banks into which the payments were made. A total sum of 895,314 naira 88 kobo, being unpaid arrears of salaries from August 2015 to June 2021. According to the claimant, on the 25th of April 2019, the defendant issued a payment advice giving a breakdown of the emoluments of the claimant, which comprised of the net salary, which was 150,401 per month, employee pension deductible, which was put at 175,848 per annum, employer counter contribution, which was put at 219,809 per annum, and 8% pension is of the total of the claimant's basic salary, housing and transport allowance, while the employer contributes 10% of same as counterpart pension. This was, however, not remitted, but was deducted from the claimant's salary every month. He further avers that other deductions made by the defendant without remitting anything are as follows: pension of 2,100 per month from the claimant's salary from September 2015 to August 2016, expected to remit 2,625 as counterpart pension per month, pension of 3,750 per month from September 2016 to September 2017, expected to remit the sum of 4,687.50 kobo per month as counterpart pension, pension of 6,320 per month from October 2017 to April 2019, expected to remit the sum of 7,900 per month as counterpart pension, and pension of 14,654 per month from May 2019 to July 2021, expected to remit the sum of 18,318 per month as counterpart pension. And then the total unremitted employee contribution for the relevant period is a sum of 590,783 naira. The claimant avers further that the unremitted employer contribution for the relevant period is a total of 739,573.50 kobo. He avers further that he was constrained to withdraw his services by resigning on the 4th of July 2020 due to backlog of owed salaries that made it difficult for him to transport himself to work, meet social, financial, and family obligations. He also informed the court that he forfeited July 2021 salary to the defendant in lieu of notice of resignation. All efforts to recover his arrears of salaries and remittance of his pension was to no avail. He also sustained injury caused by a contractor of the defendant in the defendant's premises, to which he expended the sum of 15,000 naira for treatment, and the MD promised to refund the cost, but it was never refunded. The defendant also shunned the invite to the office of the OPD in Surulere, Lagos, to resolve this dispute. The actions of the defendant has caused him trauma, forcing him to borrow from friends and family members to sustain himself and the family. The defendant's case is that one Babatunde Yusuf testified on behalf of the defendant. His case was that the claimant resigned voluntarily on the 4th day of August 2021. He refuted the claimant's claim and stated that the claimant's annual total remuneration was 840,000 naira by virtue of the provisional offer of employment dated the 15th day of August 2015. That the employment agreement did not emanate from the defendant, although he was confirmed, the confirmation of employment did not vary or modify the conditions mentioned in the appointment letter. The claimant was promoted and efforts were made to offset all unpaid salaries. He went further that the defendant paid the sum of 150,000 in August 9, 2021 to Sterling Bank account number 0074235965, another sum of 150,401,066 kobo to Sterling Bank account number 0074235965 on the 10th of February 2022. The net salary of the claimant, he stated, is 378,000 naira annually with no deductible pension. The provisional offer of employment does not contain any. He went further to state that the provisional offer of employment does not contain any provision for pension scheme. The defendant, during the time the claimant was, the defendant stated that during the time the claimant was in its employment, it never had a pension scheme for its employees. Neither did it deduct pension from the salary of the claimant or any of its employees. that the claimant did not create and did not register staff members for pension scheme, which was part of his duty, that all deductions from the salary of the claimant as provided in the contract of employment and the provisional offer of employment dated the 15th day of August 2015 was pay as you earn. The defendant further stated that all documents suggesting deductibles were fabricated by the claimant, that the defendant started offsetting the unpaid salaries of the claimant, that in contravention to the defendant's company policy, the claimant fought with an that in contravention to the defendant's company policy, the claimant fought with an independent contractor in the defendant's premises. The MD never promised to refund any medical bill incurred by the claimant. The defendant availed itself for negotiation, but unfortunately, the parties were unable to settle at the OPD. The claimant was not entitled to any pension as same was not deducted. The defendant tendered four exhibits which were marked as Exhibit D1 to D4. I have the written address of the defendant and the written address of the claimant all embedded in the body of the judgment. So I'll go straight to the court's decision. I also have the defendant's reply on points of law. It's all embedded in the judgment. So I'll go to the court's decision. The learned defense counsel in his final written address submitted that the court lacked jurisdiction to entertain this suit because there was no reasonable cause of action. Neither had a cause of action arisen. The claimant had made no demand for the debt and there was no refusal on the part of the defendant to pay. He referred to Exhibit C6 and Exhibit C7, that is the letter of resignation and the letter of appeal, and maintained that it was not a valid demand or a notice for payment of entitlement. He cited the High Court Lagos State Practice Direction number 2, 2019 on pre-action protocol, expeditious disposal of civil cases. To the learned defense counsel, Exhibits C6 and C7 were bereft of the amount being owed as unpaid salary and pension, so he could not pass for a demand notice. He acknowledged that in respect of the suit, some payments had been made upon receipt of the letters from the claimant demanding payment. This was his argument in 4.1.9 of his final written address. He also stated that he paid 150,000 naira on the 9th of August 2021 and the sum of 150,401.66 kobo on the 15th of January 2022, which was a final payoff of all the unpaid salaries. It is why the claimant's action is incompetent. In response, the claimant stated that the defendant was out to mislead the court as to the nature of this case, which is not based on a creditor-debtor relationship, but a master-servant relationship. The statement of facts by combination of facts pleaded and upon parties joining issues disclosed a triable issue and disclosed a reasonable course of action, since the court will only restrict itself to the statement of fact in order to determine whether or not there is a reasonable course of action. He also maintained that the act of neglecting to pay admitted arrears of salary and remit deducted pension constitutes a neglect giving rise to a reasonable course of action. Besides, he submitted that Exhibit C6 and C7 were admitted without objection, which translates to a valid demand notice for its unpaid salary. It is settled law that jurisdiction is the lifeblood of any adjudication because a court or a tribunal without jurisdiction is like an animal without blood, which means it is dead. A decision by a court or a tribunal cannot, without requisite jurisdiction, is a nullity, it is dead and of no legal effect whatsoever. This is why an issue of jurisdiction is crucial and fundamental in adjudication and has to be dealt with first and foremost. Per Onoge JSC in Dangana versus Usman, citation provided. A reasonable course of action is thus a course of action with some chance of success when only the allegation of the claimant are considered. Insofar as the statement of fact discloses some course of action or raises some questions fit to be decided by the court, then the fact that the case is weak and not likely to succeed is not a ground for striking out. It is the entire circumstance which gives rise to an enforceable claim. It is the reason for the claimant's grievance and complaints to the court for redress. See Thomas versus Olufosoye, citation provided. The Supreme Court also has held that what to consider if a suit discloses cause of action is one, the complaint, two, the statement of fact and the supporting document. See AG Anambra State versus AGF, citation provided. In the instant case, in paragraph 8 and 9 of the statement of fact, the claimant averts that right from the first month of his employment, the claimant started making underpayments of salaries. In some months, the defendant did not pay any salary at all. That he used three banks, that is Access Bank, Stanbic IBTC Bank, and Sterling Bank, for the receipt of his salaries, and he submitted that he would rely on the statements of the accounts for the three banks. There is also a tabular summary of salary payments received by the defendant, the balances, the dates of payments, and the banks into which those payments were made. Claimant also maintained that the defendant gave him a payment advice, giving a breakdown of his emolument to reflect net salary, pension deduction, and employment counterpart contribution. These amendments, they all raise some questions fit to be decided by the court. By the third alteration of the Constitution of the Federal Republic of Nigeria, made in late 2021, the Constitution now vests by its section 254C sub 1, exclusive jurisdiction in respect of all civil causes and matters connected to or arising from employment and labor-related issues in the National Industrial Court, notwithstanding the provisions of Section 251, 257, and 272 of the Constitution. This is per Abuki JCA in Palm and others versus ABU and others. Citations all provided. In the circumstance, this court is convinced that there is a cause of action against the defendant by the claimant for unpaid salaries and other emoluments. As for the supporting documents, the provisional letter of employment indicates that the claimant was employed and later confirmed by the staff of the defendant. That is Exhibit C1 and Exhibit C2. In paragraph 3 of Exhibit C6, the reason for the resignation is, and I quote, the resignation is necessitated by the company not fulfilling its part of the employment agreement in paying my salaries, thereby subjecting me and my family to untold hardship, end of quotation. The court has also noted with interest that the defendant admitted that for every letter received, it made effort to pay up on the outstanding salaries owed. Parties are also in agreement that the defendant made payments after the claimant submitted his resignation letter dated 4th August 2021, Exhibit C6, and after the appeal letter of 15 January 2021, Exhibit C7, was sent to the defendant. This court is also convinced that Exhibit C7, titled, and I quote, Ref, Final Personal Appeal to Pay My Outstanding Salaries, Pensions, and Other Entitlements, end of quotation, is a demand letter and a follow-up to the claimant's demand for his outstanding salaries and entitlement. Defendant cannot in good conscience argue that there was no demand made for the unpaid salaries. In the overall interest of justice, the claimant's claim of unpaid salaries and non-remittance / non-payment of pension is within the jurisdiction as ascribed to the National Industrial Court of Nigeria. This is the finding of this court. Objection is therefore overruled. The claimant is also seeking for an order for the sum of 894,314 naira 88 kobo, being unpaid arrears of salaries from August 2015 to June 2021. The claimant tendered his bank statements from the three banks where he received salary to prove the inflow of his salary from commencement of employment until his resignation. In the statement of facts and his adopted witness statement on oath, he also had a tabular presentation of the inflow of salary and outstanding balance on a yearly basis. Defendant raised issues on inconsistencies of the claimant's testimony and documentary evidence and urged the court to discountenance them as worthless evidence. Defendant argued that the employment agreement dated 13th of August 2015, which is Exhibit C3, predates the provisional offer of employment 15th of August 2015 by 3 days. After a thorough reading of the Exhibit C3, this court noted that the offer of provisional employment was dated August 15th, 2015, but effective August 13th, 2015. It is therefore not contradictory that the employment agreement is effective 13th August 2015. The law is straight that if there is an ambiguity or error in a document, it must be interpreted in favor of the party who did not draft it in its case. In this case, the employee. The principle of contra proferentem aims to prevent the drafter, usually the employer, from taking advantage of their position and to protect the employee from unfair or unclear terms. The court also observed that Exhibit C1, C2, C3, and C4 were all signed by the MD/CEO, one Paul Inyang, and besides the fact that he was never fielded as a witness in the case, there is no evidence led to prove that his signature was falsified on Exhibit C3, the employment agreement. To plead suspicion and to prove falsification are two different kettles of fish, as submitted by Leonard Claimant Counsel. Suspicion alone without more does not make a document inadmissible. This is the finding of the court. The defendant, the date on Exhibit C5, Exhibit Appendix 1, is also dated 25th April 2019. Although the document is not signed by the employer, the court noted that the contents of Exhibit 1 of Appendix 1 was implemented in terms of salary increase, which commenced on the 19th day of May 2019. The sum of 150,401 naira was paid as salary into Stanbic IBTC Bank, and similar lodgements were made in the account with descriptions ascribed to the defendant in Exhibit C10. By the action of paying the amount stated in Appendix 1, Exhibit C5, this court is convinced that the defendant participated and had knowledge of Appendix 1, Exhibit C5, and cannot feign ignorance of that document. This is the finding of the court, and I so hold. This court has also taken time to reconcile the inflow of salary into Exhibit C10 and the tabular presentation of inflow as depicted in the statement of fact and the adopted witness statement on oath, which, by the way, was never rebutted by the defendant in his statement of defense, and is convinced that this is an accurate presentation of the salary inflow from commencement of employment to date of resignation. The claimant resigned in the month of August, and in his witness statement on oath, he testified that his July 2021 salary is forfeited to the defendant as salary in lieu of notice of resignation. In view of this fact exhibited in proof of outstanding salaries, this court orders that the sum of 895,314 naira 88 kobo, being unpaid arrears of salaries from August 2015 to June 2021, be paid to the claimant. On the issue of pension, the Learned Defense Counsel has argued that the provisional offer of employment letter dated 15 August 2015 contained the major terms of the employment contract between the parties. It did not make any mention of pension deduction. It would therefore be unfair to read into the contract extraneous terms that were not envisaged by parties in a contract. The only deduction mentioned is pay as you earn. The letter of confirmation of employment, paragraph 2 of the letter expressly states, and I quote, "All other terms and conditions mentioned in the appointment letter will remain the same," end of quotation. In addition, the Learned Defense Counsel argued that the claimant failed by virtue of his position as an accounting assistant to ensure that pensions for all staff members were deducted and remitted. In this wise, the defendant cannot be made liable for such abdication of duty, inasmuch as there was no express step in the provisional letter of employment. The court, however, noted that the defendant admitted in paragraph 2 of his statement of defense the averment of the claimant in his statement of fact that the defendant is registered under KAMA 2004. The latest Pension Act in Nigeria is the Pension Reform Act of 2014, which provides that organizations that have 15 or more employees are statutorily required to register with PENCOM. The objective of the pension scheme fund is to assist improvident individuals by ensuring that they save in order to cater for their livelihood during old age. This act also introduced a contributory pension scheme where every employee is required to maintain a RSA and contribute a minimum of 8% of their emolument, while employers contribute a minimum of 10%. On the essence of pension, Obaseki Adejumo JCAP in page 76, paragraph A to B in Emokwe versus Stanbic IBTC, citation provided, stated that pension is a serious matter which should not be toyed with. A pension is to cushion the rigors of life of a person upon cessation of his employment as acknowledgement of past meritorious service to his employer. Once earned, a pension should not be withheld. It is unjust to obstruct a person entitled to benefit from a pension from enjoying the fruit of his savings. Iyizoba JCA also at page 74, paragraph F to H, also reiterated that employers pension scheme managers and PENCOM should bear the above in mind and desist from creating unnecessary bottlenecks for retirees or pensions who appropriately resign from their employment in the process of collecting their entitlement. A situation where such a person has to fall back on litigation to get his pension should as much as possible be avoided. End of quotation. The claimant is seeking for an order for the sum of 1,333,311 naira 50 kobo, being the arrears of unremitted cumulative pension accruing to the claimant from August 2015 to July 2021 to the claimant's RSC, which is Stanbic IBTC pension. The claimant has tendered Exhibit C8, which is his Stanbic IBTC RSC statement for the period of 1st of August 2015 to 22nd of September 2022, which shows that there was no remittance from the employer defendant. The defendants have, however, argued that the only deduction agreed on was payee, and the defendant cannot be held liable for non-remittance of pension contribution. This obligation, the defendant has argued, cannot be read into the contract of employment. The claimant, however, adduced evidence to show that his employment contract, which is Exhibit C5, and the employee handbook recognize his employment to include pension, and Exhibit C10 shows that the evidence and the particulars of the deductions for each month from August 2015 to July 2021. The court, after a comprehensive reading of the employee handbook, Exhibit C4, at page 34, under compensation, observed that the defendant, the employer in this case, made provisions for authorized voluntary deductions to include, and I quote, payee tax, pension, IOUs and loans, and other fines as so deemed by management. End of quotation. This court would like to state that the defendant company failed to avert its mind to the fact that pension remittance is a statutory requirement for organizations that have 15 or more employees who are registered with PENCOM. The defendant is only trying to pull wool over the eyes of the court by raising arguments of abdication of duty on the part of the claimant to schedule staff and remit deductions. After the learned defense counsel had strongly argued that the company had no arrangement for pension in its provisional offer of employment, the defendant seems to speak from both sides of the mouth on this issue. The courts have maintained that the nature of pension is like a human being with veins who receives care and support at old age from his children whom he had raised while in active service. Pension wears a human face. There is no rebuttal by the defendant as to the amount claimed as pension. What is in dispute is the fact that it was never agreed in the terms of the contract of employment. The stand of this court is that pension being a statutory requirement, no employer in Nigeria is exempted from deducting and remitting pension deductions as provided in the Pension Reforms Act 2014. The exemptions are as contained in Section 5 of the same act, of which the defendant does not fall under. The claimant has, by oral and documentary evidence in his witness statement on oath dated 14 November 2022, as reinforced by Exhibit C10, proved net salary payable and balance of his unpaid salary for relevant months of August 2015 till August 2021, when the claimant resigned his appointment from the defendant employment. In view of the above, the claimant's relief for payment of his pension succeeds, I so hold. The claimant is also seeking for a refund of the sum of 15,000 naira, being the amount expended by the claimant to treat an injury that happened to him in the defendant's premises. In support of this claim, the defendant pleaded the fact that he sustained injury on the premises of the defendant, and the MD promised to pay for the purchase of drugs and treatment from one King Clinic and Maternity. The defendant in opposition testified that it was a case of fighting on the defendant premises and there was no promise to refund the cost of treatment. There is no further explanation on how the case of fighting was resolved. Was there a query or a warning issued to the claimant? Did the claimant respond? How can the court establish the fact of true fighting? In Exhibit D4, that's the employee manual, page 21, the punishment for fighting is suspension. The defendant did not tender a suspension letter. The claimant on his part did not give details of how he sustained the injuries. The court was not told the date the incidents occurred. The first receipt is dated 21st January 2017. The second receipt is dated 2nd of March 2017. And the third receipt is undated. Page 31 of Exhibit D9 also provides for health insurance. The claimant did not plead facts to establish that the third receipt from Oking Clinic and Maternity is his healthcare provider under the insurance scheme. This court is not convinced of the circumstances surrounding the incidents, even though there are receipts before the court. In the circumstances, relief fails, I so hold. There's also a relief for general damages in the sum of 3 million naira only for the pain and financial hardship underwent by the claimant for the withholding of his salary and pension. It is right that general damages are awardable per se upon breach and is compensatory in nature in monetary form, as assessed by the court in exercise of its equitable jurisdiction to compensate the injured party by the act of the breach of contract or injury inflicted. In NACB Limited versus Achagua, citations provided, the court clarified how general damages are determined. Thus, and I quote, one of the characteristics of general damages is that it is fixed by the opinion of the court, such as the law would presume to be the direct, natural, or probable consequence of the act complained of. See also Odumosu versus ACB, Samoris versus Maja, Union Bank of Nigeria versus Ajabule, citations all provided. In the instant case, the claimant resigned on the 4th of August 2021 and is yet to be paid his entitlement. In the circumstance, the relief for general damages succeeds in part as I make an order to the sum of 1 million naira for general damages in this case. I so hold. The defendant shall bear the cost of this action assessed at 200,000 naira payable to the claimant. All the monies due under and by virtue of this judgment shall attract interest at the rate of 10% per annum from today till final liquidation. This judgment shall be complied with immediately. Judgment is entered accordingly.
As the court pleases.
As the court please, my lord, we are grateful for the well judgment of this honorable court. And my lord, the Happy New Year in advance.
Okay, thank you.
I want to thank my lord for the well-delivered judgments. We are grateful to the court and equally join my learned friend to wish my lord Happy New Year in advance.
Okay. You're welcome. Registrars, you can leave the meeting.